The statutory framework for issuance of summons.
As per section 70 of the CGST Act, the proper officer has wide powers to issue summons to any person. It must be noted that the provisions use any person, which makes the power very wide. It can be issued to any person, be he the registrant or the person who's not even registered with the GST provisions. That is one. The other important aspect is that all of these proceedings are considered as judicial proceedings, which means that again there can be wide implications if the summons are jumped. But it must be also remembered that these summons must be conducted and must be issued within the guidelines issued by the board, and it is very important to ensure that such guidelines are adhered to.
The recent decision of the Bombay High Court argued by you is unique.
When we argued before the Bombay High Court, the main apprehension of the petitioner in that case was with respect to either any coercive recovery or for arrest. So the moot point before the Bombay High Court in this unique order was whether the inquiry could be confined to the provisions of section 71. We were very fortunate to get this order from the court that the summons, when this person appears on a particular date and at a particular time, the inquiry will be confined to the provisions of section 70 subsection 1. And if we see the provisions of section 70, it says that the proper officer under this act shall have the power to summon any person whose attendance he considers necessary, either to give evidence or to produce a document or any other thing in any inquiry. So when the court confines the inquiry to the provisions of section 71, of course this is a very unique order wherein the hands of the officers are in fact confined to the provisions of 71 section 70 subsection 1, and that officer will not be able to go beyond the provisions of section 70.
What are the remedies available to the person receiving the summons?
In most of these summons, the provisions of Indian Penal Code are made applicable, and hence, as a corollary, the remedy which is there before the person who summoned is to be represented through an authorized representative. It will completely depend on the facts and circumstances of the case as well, but the equal and important remedy which is available is to challenge these summons in the court, first to check whether these summons are actually essential to be issued, two, whether the court can confine the inquiry to the provisions of section 70 subsection 1. This is what the Bombay High Court in our case has also done to confine the inquiry. Once the inquiry is confined to these provisions, the authorized person can go with in a much relaxed way. In some of these petitions, the alternate remedy could also be, or the alternate solution could also be, the advocate presence or the videography. It will completely depend on the facts and what is intended to be obtained from the person who summoned. Writ court will decide lot of such issues with respect to confinement of the inquiry, whether the authorized representative can represent the matter, or whether advocate presence is essential and relevant.